We start with the decision out of the New York State Supreme Court out in Manhattan that will allow certain evidence and toss other evidence from the trial of suspected killer Luigi Mangione, accused of killing United Healthcare CEO Brian Thompson. It's all about what happened when Mangione was reportedly stopped at the McDonald's out in Altoona, Pennsylvania. Mangione's defense team, they had argued that officers had illegally searched his backpack at the restaurant. Now, Judge Gregory Caro ruled that because the backpack wasn't necessarily in Mangione's control, legal term there, when he was detained, the evidence found during that search of the backpack at the McDonald's has to be suppressed, meaning it can't come in. The magazine, cell phone, passport, wallet, computer chip. Now you might think, wow, that's a big blow to the case. But Judge Caro also ruled that the items that were properly inventoried back at the police station after his arrest, that can come into evidence. So a 3D printed gun, silencer, which is believed to be the alleged murder weapon here, a USB drive, and of course the infamous journal, the notepad of Mangione's reported writings. Also, some statements are going to be allowed and others are not. The bottom line is, what does this mean for prosecutors? Is this case severely weakened? For that, I turn to two great legal minds, renowned criminal trial attorney Mark Geragos, who also hosts the podcast Two Angry Men and Reasonable Doubt, and retired Los Angeles Superior Court Judge, the Honorable Peter Lichtman. Thank you both so much for coming on. Mark, I'm going to start with you. To me, it seems, well, not something the prosecution wanted, obviously. If they're getting the gun in and they're getting the notebook in, isn't that still a path to conviction?
Oh, clearly it's still a path to conviction. And frankly, the real fight here is who's going to go first, the state or the feds. Because if it's one way or another, there's a double jeopardy argument. And you've seen here today the difference between the state and the federal. This decision, I would venture to say, would not have happened in federal court. It does happen in state court. And yes, you're right. The pathway to a conviction is still there for the prosecution, but it's on kind of a more steep hill for them to climb.
Yeah, prosecution, it's a headache. But here, Judge, I want to go over to you. Help us understand why the judge ruled the way that he did. It's a really important legal point. And B, you agree with it?
I do agree with it. And let me provide some context, some judicial perspective of what this judge did. And I thought he did a magnificent job, and I'll tell you why. He probably was met with some initial papers and arguments from counsel long ago about this very issue, about what should be suppressed and what the people are saying should not be suppressed. So he decided to hold an evidentiary hearing, what they call Mapp and Huntley hearings, and he did do that. 3 weeks of testimony, 3 solid weeks of testimony, 17 witnesses, and he went through the entire chronology with body cam information, and he went through the timeline completely, and he decided, he said, look, the first question he had to decide is, what law am I going to apply? Is it going to be Pennsylvania law concerning suppression, or is it going to be New York law? New York clearly is the forum, is the situs of the crime. They have what's called, in California, we call it a governmental interest test. In New York, they call it paramount interest test. Clearly, New York has the paramount interest, so they're going to apply New York law. Yeah. Now, that's kind of important because Pennsylvania has a good faith exception, has a slightly broader connotation to it and interpretation, whereas New York has 2 prongs. One is an exigent circumstance, and the other is spatial temporal proximity. And so he applied both those standards with respect to the initial search because he felt, look, when the officers came in and surrounded him, and they clearly knew he was going to be detained. To say otherwise was kind of ridiculous. Yeah. But they knew he was going to be detained, and what the officers themselves did is they moved it. They moved the backpack. It was
right, and he didn't believe this idea that there was a bomb in there or some sort of threat. Yeah, but this does raise another important question, Mark, and I'm curious. At trial, can defense attorneys point to this and say, oh my gosh, there was a problem with that search in Altoona. This shows sloppy police work. This shows that they had tunnel vision. Or is this a separate issue, Mark, that defense can't really talk about in front of the jury?
You know, Jesse, I know you only play a lawyer on TV, but it's a great question.
Thank you. I came up with that one myself.
Yeah, and it was the same question I had. I went back, and I'd be interested in Judge Lichtman's take on this, because it looked like the judge framed it such that it was not a credibility call. It was more, I'm not persuaded. And that's a tough case to make. Prosecutor will probably, what we would call motion in limine, or try to keep the defense from being able to argue that based on what the judge ruled, if you read the opinion.
So, Judge, I'll go to you. You can obviously talk about that, but I do want to ask you also about these statements. So certain statements that were made before the Miranda warning, right, won't be allowed. So this includes why Mangione allegedly lied about his name and fake ID, but certain spontaneous remarks that were made to correctional officers, those can come in. And those were about what he said about his arrest at McDonald's with, again, the 3D printing gun, his conversations on health care. I'm trying to make sense of how that affects the case and who it benefits.
Well, I'm not so sure it's going to affect the case. If you look at the timeline, once again, the judge did a really good job on this. There's actually about 1 minute and 30 seconds where he is saying that testimony can or is going to be suppressed. And then after that, where it's voluntary and everything after that, for example, where he just spontaneously has a conversation, he's already in custody. Well, that's on him. In other words, that's coming in. But the judge actually narrowed it down. He literally got by the minute and did it to about 1 minute and something like 10 or 15 seconds, and he suppressed that. I think that's a good ruling. I think that's what he should have done. But look at what the judge did in terms of the suppression, the evidentiary suppression, saying you needed a search warrant for the evidence, but then once again opened the door with respect to the inventory search. And he made a big distinction between the evidentiary search and the inventory search. Yeah. Now, as the inventory search turned out, since Altoona did have a rigorous policy of how they conduct these inventories, everything comes in. So he allowed that in. So you've got to lead off with your initial question to Mark there. You've got the gun, and you've got the notepad, the manifesto, so to speak. So.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.